the governor hasn't signed it, and what are the chances he won't sign it?
Well, it hasn't even been presented to him yet for some reason, which is kind of strange. I mean, I think he'll sign it, but, we just want to make sure we make it clear that it's, ain't a done deal yet.
Okay, well, did you look at the PowerPoint, Lester?
I have not had a chance to. I really quickly scrolled through it, which is what prompted me to look at the bill to see what the status is.
Okay, so all the law changes Rachel was kind enough to put in red.
Right, yeah, I saw that, which is fine. We can talk about it. We just have to make clear that it's not a done deal yet.
Right. Okay. So we've already also rewritten the book, so as soon as the governor signs the book, we'll be able to put out the second edition.
There's an interesting problem with the PIP bill. The PIP bill took the healthcare clinic exemptions out of Chapter 400. And so that now Chapter 400 has no exemptions.
Really?
But it moved them to Chapter 6, to the PIP statute, which is 637 somewhere, and put the exemptions back in. But the problem is it took them out effective July 1, and it replaces them effective January 1. So that means there's 6 months where physicians' offices, anyone who's not licensed as a clinic, could not bill PIP unless they get licensed. And there's about 30 to 40,000 of those in the state. So obviously they're not going to get licensed. So it's appearing like, according to my sources in ACA, that the governor may actually have to veto this bill and call a special session. Remember, that bill only passed by 1 vote. So,
oh, this bill only passed by 1 vote?
Yeah. So this could be, he could have major egg on his face. With total, no one asked ACA to look at the bill. State Farm essentially wrote the bill, and State Farm admitted it didn't think about that issue, and there's probably some other glitches like that it didn't think about.
Okay.
So, I notice we don't have any audience on yet, just presenters.
Yeah, is anybody? We have one person.
Who?
Wendy Tinger, T-I-N-G-L-E-R.
Okay. She doesn't show up on my...
And Dr. Singh is logging in. So,
there. Hi, Alan.
Hi, how are you?
I'm okay. How are you?
I'm doing great. Doing great.
Hey, Dr. Singh, it's Lester.
Hi, Lester. How are you?
I am fine, thanks. How about you?
I'm good, thank you.
So this one, although we have a very small audience, this will be recorded for the Southern Medical Association.
Okay.
Great.
And how do we want to start this? Dr. Singh, do you want me to just introduce and then you talk for a couple minutes and then Lester and I talk about it, then you talk at the end? Isn't that what we did last time?
Yeah, I'm fine either way.
Lester, is that okay with you?
Sure.
Okay.
I'm easy.
So I think what I'll do is I'll introduce the 8 mistakes in 8 minutes, and then I'll introduce Dr. Singh, then Dr. Singh will talk for a few minutes, then we'll go back to the technical points, and then we'll end up with Dr. Singh at the end.
Okay, good with me.
We'll dance, we'll sing, we'll tell jokes.
That way, Dr. Singh, you can kind of nap during the middle. So.
I'll have my lunch. I'm having my lunch.
Yeah, no snoring.
Yeah,
right.
No snoring.
You want to go ahead and get it started?
The broadcast is now starting. All attendees are in listen-only mode.
Hi, this is Alan Gassman, and it is Tuesday, April 10th, 2012 at noon, and we are here to talk about the new Florida Guide to Prescription-Controlled Substance and Pain Medicine Laws. And it is new because we have a new legislative session that just finished up. Some new little confusing changes to these rules if the governor signs them. And importantly, our co-speakers, Lester Perling, the lead author of our book on pain medicine rules, Dr. Singh, the lead doctor on our book on pain medicine rules, and everybody's idol, and myself there on the right. And just to get this started, I'm going to go to page 2, and everyone attending should have received an email of this PDF, and you're welcome to download it. and forward it to anyone you like. But just to give you a general gist of these rules, I want to go over the 8 big mistakes in less than 8 minutes. So if you're watching this webinar and you want to know what you're going to get from it, let me tell you a few things. Mistake number 1, failing to write the prescription on a controlled substance prescription form and with a counterfeit-proof prescription pad. That's vitally important. And failing to treat your prescriptions like they were money. They're very, very important. They can't be lost. Mistake number 2, if you're prescribing for chronic non-malignant pain, failure to be registered as a controlled substance prescribing practitioner. Unless you fit into one of the exceptions that we talk about, and many doctors don't, you have to be registered as a controlled substance prescribing practitioner. The deadline was last December 31st. Mistake number 3, failing to satisfy all the documentation and standard of care requirements. This is not only because of the pain law, but this is also because you may be sued for malpractice. The standards of practice are going to be different when you're prescribing pain medicine. The juries are going to see to that. Mistake number 4, failing to satisfy the pain medicine record documentation requirements in the regulations. That ties into mistake number 3. Mistake number 5, dispensing the Schedule 2 or 3 controlled substances beyond the exceptions that we're going to talk about. Mistake number 6, again, failing to register as a dispensing practitioner with your licensing board. Mistake number 7, failing to use the eForce website. We're going to tell you about the eForce website, and if you haven't been using it and you are a physician or a medical office, I think you'll want to start using it for the reasons we talk about. It's going to help you to help your patients and to protect yourself. And mistake number 8, not registering as a pain management clinic if you're not exempt from the registration requirements. And believe me, there's a lot of mistakes being made by pretty smart people out there who think that they're not required to register and follow all these rules, but unfortunately they are. Okay, I'm going to go ahead and let Dr. Singh say a few words now about what this means to a medical office and a physician and to patient care in general.
Thank you, Alan. First of all, thank you for inviting me for this webinar, and it's a pleasure to be here. I'm very happy that this legislation passed, and for my own reasons, it has improved my practice. And I think if everybody takes it seriously, even though it can be a little onerous in the beginning, it can help us all become not only better physicians, but better documenters and more compliant providers to our patients, and ensure also that and realize also that we have a social responsibility, not just being in a room, entering the room, writing off prescriptions and walking away. And it's also part of our proper approach to any patient, a team-based approach, a goal-based approach. The 8 things that we frequently err on, I'm sure Alan will talk about, but to me the biggest take-home message from this was to create a culture of compliance in the practice, making sure everybody in the practice realizes that people who are on medications which are controlled and which come under the purview of this legislation, we take it very seriously, because not only for legal reasons, but if we do not take good care of it, these patients can potentially get hurt very significantly, and some of the patients can die, as we have seen in previous news reports. There is a checklist at the end of the book and at the end of, I think, this presentation, and also a diagram that I had suggested. We are using that in our practice for almost every patient, and also it has become a CMS requirement for anybody who is doing managed care. It's part of the star rating. So when you do one thing, you're going to automatically ensure that your star rating improves and you become more compliant with your HMO requirements. More of that later, but I'll pass the baton now to Lester to walk us through this legislation, which can be a trifle confusing and sometimes complex to understand.
Good afternoon. It's Lester Perling. Glad to be here. Alan, you want to sort of give us, well, maybe I'll just kick off by talking about this first slide that's showing here regarding, I think, one of the Well, on the face of it, at least, it's one of the key potential changes to the statute, which is a change in the definition of chronic and non-malignant pain that will be effective July 1, should the governor sign the bill, which I would anticipate he will, but you never know till it's done. And that change is the removal of rheumatoid arthritis as part of the definition of chronic non-malignant pain. So the statute, as you see it there, will change so that it will now just be cancer as the only specific sort of, if you will, disease entity mentioned, not rheumatoid arthritis. I think at the end of the day, that is a distinction without a difference, because Part B of the definition is any pain that persists beyond the usual course of the disease or injury that is the cause of the pain is considered chronic non-malignant pain. I'm not a rheumatologist. I didn't even play one on TV. But I think most rheumatologists would tell you that pain is certainly part of the usual course of the disease, and that is a lifelong occurrence. So that's why I say that the removal of rheumatoid arthritis as a specific part of the definition of chronic non-malignant pain may not really have much of a practical effect. And then the other part of the definition is pain that exists greater than 90 days after surgery. So surgical pain that is occurring within that 90 days post-surgery is not chronic non-malignant pain and would not be included in the statute. The other thing I think the bill did that relates to this slide is removing Schedule 5 drugs as being included in a requirement to register as a prescribing practitioner. But I think we'll probably get into that in a later slide. Alan, you want to pick up?
Just to go back to the 35,000-foot view here, what they really are trying to regulate here are prescriptions for chronic non-malignant pain, which, as Lester said, is pain that's unrelated to cancer, unrelated to rheumatoid arthritis as of today, and it persists beyond the usual course of treatment, which Lester's going to talk more about. You know, somebody sprains their ankle, it really hurts. How long is that usual course of treatment? Then they say, well, you know, I'm beyond when that ankle should be hurting, but I still need that pain medicine. And that's where the legislators want all the red lights to go off and for these rules to apply. Or for surgeons, 90 days after surgery, which we're going to talk about. And then, as Lester said, the legislation just took out the exception for rheumatoid arthritis, but rheumatoid arthritis may still be accepted because the usual course of treatment for rheumatoid arthritis is pain medicine. So now let's go to the next page. As soon as I figure out how to get to the next page. And we're going to go to number 1 here, and these are the rules that apply to all doctors, whether you're writing a pain prescription or any sort of controlled substance. Lester, do you want to go over these rules?
Sure. The first rule regarding, well, of course, maintaining the control and security of prescription blanks. I mean, there's nothing new and certainly very critical. And of course, that would include, if you're an e-prescriber or electronic prescriber, maintaining control of your passwords, etc. But maintaining control of prescription blanks and passwords is critical. I have a client who recently discovered a bunch of his prescription blanks had been stolen and were being used as part of a very large organized ring of prescription drug nefarious behavior. And fortunately for him, he did as he's supposed to in bullet point 2, which he not only reported it to the Department of Health when he discovered it, but he also reported it to the police, which is bullet point number 3. And part of that is just simply to be on record contemporaneously as having had this theft of the blanks. You know, it might be harder to report to the police. You may not even know your password has been stolen, but certainly theft of the prescription blanks themselves, so that you as the prescriber are on record as having reported this occurrence, because sometimes the law enforcement agencies will look back to the physician to determine their degree, if any, of involvement in any sort of prescription drug ring. So that's kind of just a self-protective self-protective measure, not required by law necessarily, but certainly a good idea. Physicians sometimes are reluctant to do that because they don't want to basically look stupid, but nonetheless, it's something that I think is important to do. And the next bullet point reflects the specific requirements for a controlled substance prescription, which I won't go into detail, but obviously it's important that they all be there, and any good pharmacist will reject the prescription if all of the required elements are not present. Alan?
I'm going to go ahead and go to slide 2, which is the DEA requirements for prescribing controlled substances. And the only reason we include them here is because everyone should know that you have to follow the federal laws and have your DEA paperwork in place. We don't want anyone to be confused into thinking that just because you comply with the DEA rules doesn't mean you have to comply with all the Florida rules, because you do. Okay, now we're going to go to number 3. And this is probably the most confusing thing in the law now for most doctors, and that is the registration requirement for these physicians who prescribe for chronic non-malignant pain. And let me just tell you from 30,000 feet, if any time in 2012, any one patient, which could include your mother-in-law, is going to get a prescription from a doctor for chronic non-malignant pain, that doctor has to register before writing that prescription, and a great many doctors have registered. Lester?
All right. As I mentioned on the earlier slide, the statute as it now exists requires registration for any, if the physician prescribes any controlled substance. The legislation that has passed deletes Schedule 5 as a basis for registering, probably because of the low level of risk associated with Schedule 5 and the fact that it probably helps to unclog the system. When this requirement first was passed in the last legislative session in 2011, there are a lot of physicians who were very concerned about having to register, and would that bring greater scrutiny on them from state agencies, and we're looking for ways really to try to justify not registering. And I think that's the wrong approach, because I don't think that, one, registering is going to create any greater scrutiny, because as a prescriber, the information goes into the eForce data bank that we're going to talk about later anyway, and physician prescriptions have always been monitored by law enforcement, by Medicaid, by others. So I don't know that it's going to add any scrutiny that otherwise would not be there. And so I don't know that registering is really much more at this point than a ministerial act. Certainly it does disclose to the government you're involved in this behavior, but I'm just very doubtful it's going to bring any more scrutiny than already exists, and physicians already are heavily scrutinized for their prescribing patterns with regard to controlled substances. So as Alan says, even if you just write one prescription for your mother-in-law, Alan always uses mother-in-law for that example, so I'm not sure if he's looking to have his mother-in-law under a state of sedation most of the time or not. But anyway, we'll let him explain that one.
My situation.
And so registering, I think, is not a big deal. And again, going to great pains to try to avoid it or get a legal opinion that somehow in some tortious fashion says that the physician doesn't have to register, which is not something I would give, but a lawyer might, I don't think is really a good idea, and I don't think is really that helpful.
Right. I mean, you could even make an argument that a malpractice carrier would deny coverage because you're illegally writing controlled substance scripts. So you want to be careful there. Now, Lester, a little bit of confusion, this new law that the governor may sign. What are they talking about with Schedule 1 and Schedule 5? And how is it important or unimportant when you?
Well, Schedule 1 isn't particularly included because no one can write a prescription for Schedule 1 drugs. Schedule 1 drugs are the heroin category of drugs for which there is no, at least in today's thinking, legitimate medical purpose. And so doctors can't write a prescription for Schedule 1, so they're not included in the registration requirement, because they don't need to be. And as I mentioned, Schedule 5 drugs are those drugs that have the least potential for abuse. I mean, the schedule runs 1 through 5, 1 with the greatest potential for abuse, and 5 with the least potential for abuse. I don't think that there are any pain medications or narcotics that are being sold on the street or abused that fall into Schedule 5. And so I think that's why the legislature took it out. It was just not really relevant to the issue that was being that's being addressed.
Okay. All right. Very good. Well, that clears up our next chapter of the book to explain that. All right. I'm going to go to 3.1, and here's some exceptions to the registration requirements. And this would be doctors in this situation would not have to register. The first one would be treatment of chronic non-malignant pain. Then also post-surgery, if you're a surgeon, you have to write at least every 14 days and up to 90 days in total. So that's 4 2-week intervals. Cancer medications, pain medications given for cancer would not count. Then you have the rheumatoid arthritis. Lester, you want to talk me through what's changing here for rheumatoid arthritis, if anything?
Well, again, in the statute as it currently exists, if a physician is only treating patients with the controlled substances for rheumatoid arthritis, then they're not obligated to register. Under the statute as it's revised, rheumatoid arthritis would be deleted as an exception. So theoretically, if a doctor's treating rheumatoid arthritis, they would have to register unless D applies, which I'm sure we'll get to. It's not clear to me why they did that. It doesn't, I guess it wasn't really clear to me why, other than cancer, rheumatoid arthritis was the only other specific disease that was mentioned. There's certainly plenty of other conditions that cause chronic pain, that are known to cause chronic pain, for which patients are going to have to be treated on probably a lifelong basis. So why they specifically included rheumatoid arthritis in the first place is a little bit unclear, and maybe that was a result of lobbying done in the last legislative session. And why, and on the other hand, why they took it out at this point is unclear. As I mentioned, it seems to be somewhat of a difference, a distinction without a difference, given what we see here in D with regard to the usual course of disease or illness, which I guess I'll just roll right into while I'm talking about it. I mean, that's kind of the big potential loophole if a doctor is looking for a reason not to register, to say that he doesn't treat patients with chronic non-malignant pain. So as I mentioned, I mean, rheumatoid arthritis, I think, is one that causes pain throughout the course of the disease, but other forms of arthritis do so as well. I've had doctors, endocrinologists, ask me about diabetic neuropathy, which is a common side effect of diabetes, very painful, and is also probably going to last for those patients who suffer from it during the entire course of the disease. And the course of the disease at this point runs until they die. Hopefully that will change someday, but that's the way it is currently. I think if a physician is going to say, I don't need to register because I only treat patients with pain during the usual course of the disease, they really need to be able to justify that. And just the doctor's bald assertion that, well, I only treat patients who have pain as the usual course of disease, really isn't going to be sufficient. They have to be prepared to defend themselves should it come up, to show that, yes, indeed, this particular disease has lifetime consequences, or that this particular patient is still in the usual course of the disease, and that's why I'm treating the pain without registering. So, for example, we'll go back to Alan's sprained ankle that he mentioned at the outset, a sprained ankle really only has acute symptoms, generally speaking, for a limited period of time. What that period of time is obviously is going to differ, I'm sure, from case to case, person to person. So if a physician says, well, look, this is obviously a far-fetched example, but I didn't give, I didn't register, even though I've been giving that patient pain meds for his sprained ankle for 90 days, he better be able to show that it's the usual course of an injury to have pain after 90 days. That's an objective measurement. That's not subjective to that patient. So even though that patient may well have pain 90 days later, and there's nothing there that can be found to be repaired surgically or whatever, I think that a physician would be hard-pressed to say that's the usual course, because, again, that's an objective standard, not a subjective standard. And that's I think, the exact type of thing that the statute was, at least in part, designed to get to, is patients who are legitimately taking pain medications and then illegitimately taking them, we'll call it, due to getting hooked. And that's the type of patient that would be at potential risk for that. So I think the key point there is physicians need to remember that they're going to be judged on an objective standard if they're trying to claim that's why they didn't register.
Okay, very good. Dr. Singh, any thoughts, by the way? You can always pipe in. Okay. Now, note number 1 here at the bottom. You can prescribe medications for anxiety or sleep. If it's not for pain, then it's not going to be regulated under these rules. Is that right, Lester?
Well, correct. Again, in order to be regulated, you're prescribing the drugs to treat pain. So someone who has severe pain, let's say, or even chronic pain, like because of rheumatoid arthritis, we'll use that one, may well have anxiety or depression related to having that condition. It's probably somewhat common. So if the patient isn't getting, at this point, controlled substances to treat the pain, but let's say is getting something to deal with the depression may be an outflow of the fact that the patient has chronic pain, but the depression medication or the anxiety medication being given, or the sleep medication, should be documented as being given for the purpose it's normally used, which is to treat insomnia, to treat pain, to treat depression or anxiety, and at least arguably, in my interpretation anyway, that would not be for the treatment of pain, even though pain might be present and those conditions might be secondary to the pain. I think most physicians would say, look, if I'm prescribing Ambien because my patient with pain can't sleep, the doctor would say, I'm treating the insomnia, I'm not treating the pain. And so that's the distinction in that regard.
And that's what would be put in the patient notes.
Correct.
Okay. Then, not exempt from the registration requirement, board-certified anesthesiologists, physiatrists, neurologists, and surgeons, if they are prescribing for chronic non-malignant pain. So it's very important to follow these rules. Okay, I'm going to go now to the next slide here. Find my cursor. And the patient documentation requirements, again, very important. And these are out of the rules. If you're going to prescribe for chronic non-malignant pain, you have a lot of things to put in your medical record. And this is not only required by the law, and it's required even if you're exempt from registering, but this is what juries are going to want to see. This is what the plaintiff lawyers are going to ask you why you did or did not document these items. Lester?
I think that these things are required for individuals who are registered. So for physicians or practitioners who are registered. So if they're not present, then they certainly subject the physician to potential discipline by their licensing board. But I think beyond that, Alan's right that in a malpractice proceeding, let's say that a patient who was getting chronic or getting regular pain meds overdoses, and the family sues, the physician better have been documenting that he's following these standards. Because failure to do so, I mean, this is obviously, the legislature has set this as the standard of care in this area, and this is what any plaintiff's lawyer is going to look to demonstrate to a jury that the physician failed to follow the standard of care. And even a physician who doesn't register, however, is prescribing pain medications to treat pain, but may fall into one of the categories that would exempt them from registration. Arguably, this type of documentation is going to become the standard of care for them also, which is another reason why not registering, trying to avoid registration doesn't really make that much sense. Because I think most plaintiff attorneys would say, that yeah, you're an exempt from registering, that's fine, but you were treating a patient using narcotics over a long term, and don't you think these things are relevant to that patient as well? Don't they deserve the same care and attention as a doctor who has to register? There's no distinction between the two in terms of what benefits the patient. So I think this may well sort of become the standard of care, if you will, whether or not the physician is registered.
Okay, very good. Now, a little bit of humor here. One of the rules is that patients exhibiting signs or symptoms of substance abuse who require a referral have to be referred to a board-certified pain management physician or a physiatrist, as the law is now written, because they confuse the word physiatrist with psychiatrist. So the new law, which will take effect July 1st if Governor Scott signs it, will now allow you to send a patient with addiction issues to a psychiatrist as opposed to a physiatrist. And I'm sure all the physiatrists are very glad of that, and so are the psychiatrists. Now, on the other hand, a lot of psychiatrists are expecting, or were hoping, that they would be exempted from having to register as pain management practitioners and from being a pain clinic if they were treating pain medication patients. And that is not the case, as we'll discuss in a little while. Okay, going to 3.3, here's the exemptions to some of the documentation and standard of care requirements. But even though these particular physicians don't have to comply with all the documentation and standard of care requirements, I sure would. Because again, when you get called to the jury trial because that patient overdoses or had an addiction issue or caused a car accident because they were on too much pain medicine, you're going to want your charts to show that you followed everything that Dr. Singh is going to tell you about towards the end of this webinar. All right, then we have some changes to the standard of care requirements, which will cause further confusion, and that is basically that board certified became board eligible. So board certified doctors who were exempt from some of these documentation requirements now will be able to have their board eligible colleagues also exempt. Again, because a practical matter, I would still fulfill all the documentation requirements, and we'll talk later about what the other board-eligible exceptions are that will apply July 1st if Governor Scott signs the bill.
I think, Alan, one of the key things in that last slide with regard to the potential change actually is number 3, because that was a major concern with regard to physicians who, particularly hospitalists who only treat patients in the hospital, and it was, I think, a result of lobbying that was inserted. And actually, a member of the Board of Medicine is a hospitalist, and that, I think, it became an issue for them. Interestingly, what it did not do was exempt emergency room physicians who thought they should be exempt as well, but obviously that did not happen because this is only an inpatient stay.
I see. That's interesting. Okay, we'll make sure we put that in the next edition of the book. Taking very good notes here. All right, then how to register as a controlled substance provider. We have the information here at page 12. We'll let you go ahead and use that if you need it. All right, then the administrative regulations that apply to all doctors who write prescriptions for controlled substances for treatment of any pain, not only chronic non-malignant pain, but any pain whatsoever, are here. And you're going to want to read these if you're a physician or you're managing physicians or you're doing medical documentation for a physician to make sure that these things are being done. These rules are a little bit different for the DOs than they are for the MDs. So we've summarized the MD rules here and the DO rules, but if you want to really make sure you're following them exactly, let us know and we'll email you a comparison of the two sets of rules. Lester, any comments on this?
No, other than I think that a lot of physicians have forgotten that these rules exist and have existed for quite some time. These are not new. They're totally unrelated to the registration requirement and in fact, unrelated to all of the current hoopla about the issue. This predated them, so it's a good reminder that these rules do exist. And they are, in large measure, similar to what's in the registration requirements, other than maybe a couple things. One example being referral to an addiction specialist if needed is not required under these standards. But so it is important even for physicians who don't register and who don't want to follow that standard of care, that these rules remember that these rules still exist and are applicable to them.
Okay, very good. All right, now I want to spend just maybe a minute on Part 5. That's simply that you cannot dispense medical drugs from your office unless you meet one of these rigid requirements or you register as a dispensing physician. So if you are dispensing controlled substances listed in Schedule 2 or Schedule 3, other than complementary packages of medicinal drugs clearly labeled as a sample, or having to do with a surgical procedure, or having to do with a study, you are going to want to stop doing it or register as a dispensing physician office, in which event you're going to be treated just like a pharmacist is treated, with a lot of requirements, which may or may not be worthwhile following depending upon profitability of your operation.
Actually, Alan, to clarify there, what the statute does is it prohibits dispensing practitioners from dispensing Schedule 2 or 3. There used to be a dispensing practitioner who's registered with the Department of Health as such could dispense Schedules 2 through 5. Under the statute last year, they can no longer dispense 2 or 3 unless one of these exemptions apply with regard to things like the samples or related to the surgical procedure. But in terms of general dispensing, they cannot dispense Schedule 2 or 3.
Okay. All right. Then, of course, the registration requirements are at 5.2 if somebody wants to register for this. 5.3, the dispensing requirements are there for anyone who wants to follow them. 5.4, big punishments for those who don't follow these, leading us to Part 6, which is the Florida Prescription Drug Monitoring Program. And Lester, you give a great talk on this, so I'm going to just let you explain this.
This particular program that went into effect last year is designed to capture data with regard to patients who are receiving these controlled substances. And what the law does is simply require that any dispenser of controlled substances has to report within, I think, 7 days of dispensing to the eForce database. And this is all based on dispensing, not ordering. So the ordering practitioner has no obligation with regard to reporting to the database unless they are a dispensing practitioner. So this law generally is going to apply, for the most part, to pharmacies, whether they're retail pharmacies like CVS or hospital pharmacies. From a physician perspective, the important point here is that while physicians are not obligated to look at eForce, although there was a measure proposed to require it that it did not pass, physicians would be well advised to do so. It's fairly simple to register for the physician to gain access to this, and because reporting is required within 7 days, the information in it is quite current, and it allows physicians to take a look before they prescribe the substances that particularly have some sort of potential for abuse to determine whether or not someone is already prescribing these drugs for the patient, even in an acute situation, well, if someone comes in, they broke their arm, and there's no reason to think they're using these drugs. Otherwise, maybe it's not as relevant. But my personal feeling is that before prescribing something that has at least the potential for significant abuse, really in any patient, that the physician check the database. And I've already heard from a lot of physicians who tell me that they've been quite shocked when they checked the database to see that patients to whom they were prescribing these substances were in fact doctor shopping, and they would not have guessed it about these individuals in a million years. And I think that's a good lesson, because folks who abuse these drugs are not junkies necessarily, or only junkies who are living on the street. They're doctors, lawyers, Indian chiefs, and they're people that the average physician might not suspect. And they're quite functional on the drug, and so there's no signs of abuse. But lo and behold, they are in fact doctor shopping. And when that occurs, I think the appropriate step to take is for that physician to not prescribe the drug, because Lord knows you don't want to be the last one on the list of prescribers that causes the overdose, particularly when you didn't even bother to check to see what was going on with that patient. So I think it's really critical for doctors to be routinely checking this list, or having someone on their staff check the list before they prescribe these substances in most circumstances.
Okay. Very good. And again, going back to the jury trial scenario, I would see a plaintiff lawyer saying, why didn't you check with E-Force when you prescribed these pain medicines if you had known that this was an addicted person who was so drugged up that they couldn't avoid lying? You could have saved their life before they jumped off the bridge.
Or I think, Alan, even if it's not one of those people, but had they not prescribed it, they could have perhaps prevented the overdose, even though they weren't obviously a drug addict. I think that would still be an issue.
Right, right. And the instructions on how to access the patient information is on page 6 and point 4 and 6.5. Then going to section 7, the registration and inspection requirements for pain clinics. So I'm going to give you the simplistic approach, and then Lester's going to give you the more accurate approach. But basically, the first question is, are you a pain clinic, or are you doing anything that would cause you to be characterized under this law as a pain clinic? And all you have to do is advertise in any way that you provide any type of pain management services. And if you are a medical or osteopathic practice, or you fall under other certain categories of practice, and you just have the word pain somewhere in your website, then you are a pain management clinic. And of course, most pain management clinics are smart enough to use the word pain because they know that that's what brings the business in. The alternative is, even if you don't use the word pain, if in any month you're prescribing pain medicine medications for chronic non-malignant pain for the majority of the patients you see, then you are a pain management clinic. And unless you meet one of the exemptions that we're going to talk about, you have to register and you have to follow these rules. And if you have separate locations, each location has to be registered separately. Lester, what do you think? How am I doing so far?
I think you're doing good. I think the one thing to point out is that the Board of Medicine issued a declaratory statement in which they gave their opinion on various scenarios presented by the Florida Medical Association as to whether or not specific hypothetical ads might require registration, and it was very broadly interpreted. And, Alan, you're correct when you basically talked about if the word pain is in there, registration is going to be required. I guess the only thing I would add to what you said, Alan, is that this requirement is separate and apart from the registration as a controlled substance prescriber. Just because you're not in something that might qualify as a pain management clinic doesn't mean you don't have to register. And I think there's some confusion because the definition of chronic non-malignant pain overlaps the two different regulatory requirements, but these are independent requirements that have to be analyzed separately as to how they might apply in a given situation.
Okay, I'm going to skip a page here, and I'm going to go from page 25 to page 27 as soon as I get my cursor working for that. In page 27, we're going to show you the doctors who don't have to register as a pain clinic. Obviously, that's very important to them. And this would be a practice where the majority of the physicians provide surgical services. They would not have to register as a pain clinic, even if they advertise for pain. And second, wholly owned and operated 100% by board-certified anesthesiologists, physiatrists, or neurologists. Now, psychiatrist was not added to that, so you could only be board-certified anesthesiologist, physiatrist, or neurologist, or wholly owned and operated by board-certified specialists who have the pain medicine accreditation from these two accreditation organizations. If you are 100% owned and operated only by these board-certified categories, you don't have to register. Now, if you're owned by the husband neurologist, board-certified, and the wife who's not a board-certified or or eligible neurologist, then that doesn't work. You would have to have the stock wholly owned by the specialist physician. Big change that we're looking at having happen in July 1st, if Governor Scott signs this bill, eligible physicians will also be able to be owners. Change for a lot of medical practices. And also, rheumatologists are going to be able to be owners of pain medicine clinics under this new law. Big change for a lot of groups. Now, let me also mention that you may be 100% owned by board-certified anesthesiologists or these other categories, and therefore not have to register. But if any physician in your practice who prescribes for chronic non-malignant pain is not fitting one of these categories, then you still have to go back and register. That's a complicated part of the rule, but one that I wanted to make sure I mentioned. Lester?
I think you hit it, Alan. I'd just point out too that in the legislation that passed, that a physician multi-specialty practice would be exempt so long as one or more board eligible or certified medical specialists, pain specialists, are practicing. Now that won't apply if it's to neurologists, physiatrists, etc. It only applies to C there, not to A and B. So it gives a little bit more flexibility, or not flexibility, sort of helps the multi-specialty groups that among them include a pain specialist, so that they would not have to register just because of the presence of that one person.
Okay. Then just going back to page 26, look, the Department of Health can deny registration if it's not 100% owned by the licensed physicians. So we're going to expect that Tallahassee's not real happy with non-physician owners of pain medicine clinics. We've seen some real nightmares, some awful things going on. So we're going to expect that we're not going to see pain clinic registrations granted to anyone other than hospitals, systems, doctors, and other more reputable categories. Lester, has there been any input, or is there any experience with anyone who's tried to register since these rules came out?
I haven't heard of any real controversy, no, but it is important to note that it's not that they can't grant it, is that it gives them the discretion not to if it's not wholly owned. I have not heard of controversies yet. There may have been some, but just not have come to my attention.
Right, right. Okay, then the designated physician on page 29, if you have a pain clinic, you designate a physician, and that physician is responsible for everything going on in that clinic. It's a huge responsibility. You have to read the responsibility list, and you have to decide if you're getting paid nearly enough to be the designated physician at a clinic if it's not your clinic. Lester, you agree?
I do.
Okay. Now, of course, at Section 7.4, there are many ways that they can revoke or suspend the registration of a clinic. And at Section 8, there's new crimes and penalties involving controlled substances. The government is very, very serious about enforcing these rules. Florida has become the armpit of the country when it comes to pain medications. People drive down from all over the country with vans full of pain medication patients who get bottles of pain medication, take them out to the parking lot, hand them to their sponsors. Who knows what's going on with these medications? More deaths now in Florida are caused by pain medication overdoses than traffic accidents. So the government is absolutely serious. People with badges and guns who work for law enforcement all over the state are actively investigating pain management establishments. Don't think they're not. If you're involved with one, you want to make sure the rules are being followed. Now,
another point, Alan, just to mention briefly, is that a lot of localities are, counties and cities are passing their own ordinances that are regulating pain management clinics, even beyond what the state is doing in terms of where they can be located and whatnot, basically making it very, very difficult to get the necessary local permits to even open a clinic, even if they might otherwise meet the state's requirements. So it's also important, if you're operating in this arena, that you pay attention to local ordinances, because many local jurisdictions, including Hillsborough County, have their own ordinances regarding these types of facilities.
Okay, then Chapter 9, we have the rules that apply to pharmacists, which help describe why pharmacists are turning back so many prescriptions because they're afraid of license complaints with all these rules that apply to them. And now we've really saved the best for last. Dr. Singh, are you with us?
Yes, I'm here.
Excellent. Okay, I am at page 36 now, and I am looking at your fantastic pain prescriptions checklist. And what I've done is I've taken your one-page document, which you designed to go in on the left side of a patient chart, and I've moved it into 2 pages. The top part is on page 36. The bottom part is on page 37. And then beginning on page 38, I've got your sample pain assessment form. And beginning on page 39, I have your compliance article. So I'm going to turn it over to you. We've got about 9 minutes. I'm really looking forward to hearing what you have to say.
All right, thanks, Alan. Well, I'll try to squeeze it in 9 minutes. Important things, I'll just go quickly over this. Please evaluate your patients every 3 months, even if they're out of town, if they have sudden emergency. This is the law. You don't play around with the law, especially patients who habitually call at the last moment for pain medications out of town. Advise them to see a pain specialist wherever they are, or even an internist. So please make sure you document some evaluation every 3 months. Basics of medicine do not go away. Good history, a good exam, an evaluation of labs, any radiological studies, and consultants. These are, this is part and parcel of our examination, and this is, I believe, this is nothing new. We should have always been doing it. Now it has become mandatory, and I'm glad it is, because it just has made, has forced us to start looking at it. We have put this list, this checklist in our EMR, so automatically it doesn't have to be filled in every time, but once a year it should be filled, and every time they come, you should have a quick reevaluation of their pain status, and we'll come to that diagram which we have drawn on a later slide. Also, there are secret shoppers going around. A physician was arrested, I think last year, in our locality for not even talking to the patient, not even examining the patient, just writing the narcotics. And this patient was a secret shopper, and the physician was arrested and lost his license. On another thing that Alan had brought up with marketing, please make sure when even your chiropractors market low back pain, the moment they say low back pain or headache or neck pain, it becomes part of the whole shebang with the pain clinic. So either my recommendation is to not even mention pain in your marketing, especially if you're a family physician who's doing sore throats and blood pressure and diabetes, and just throw in low back pain. There you just enhance your appeal to physicians, I would recommend we remove it. It's very important to review what the consultants are doing. I strongly recommend a very good EMR system, which we have, so that any consultant who has written a note or done anything, if he's part of your group, it automatically is part of your EMR. If he's not, it is automatically scanned in your EMR, and I would make it a standard to ensure that all your referrals, your reports are coming back in your EMR or in your record. Please do not forget pain contracts. I ensure that anybody who's getting pain medicines from our clinic gets signed pain contracts. Without it, I do not like to give any pain medications. If a patient has been on pain medications for even for chronic condition, I would always look to taper off and have a little plan to try to taper off. If it's not possible, it's not possible if the patient has pain, but at least show a good faith attempt to try to reduce the pain medication. Alan, can we move to the next slide? So I recommend, I mean, this is the checklist that what we did was we got these printed on very fluorescent yellow and green paper, thick paper, and we put that in the charts. Those people who are using paper charts, this is on the left-hand side to be as a checklist and as a reminder. And people who are using EMR, we have put that in the EMR as part of your note. So it just makes sure that you do go over this. As I mentioned earlier, an evaluation of pain is now a HEDIS requirement. So anybody who does managed care or ACOs or medical homes, it is going to be a mandatory part of your evaluation. And that is also another reason why this is very helpful to document what level of pain they have and what your plan is. On this pain prescription checklist, prescriptions on a counterfeit proof prescription pad, Alan has already discussed it. The quantity has to be there. You have to write it down. The date has to be there. It has to be legible, and those are very important things. Your signature and your DEA has to be there. If you're writing medications for anxiety or for insomnia, you should document in your progress note that you're treating chronic anxiety or persistent insomnia or chronic insomnia, and that is why you're giving these medications, so that it is clear from the chart that these are not being given for pain issues. It is good to be careful with these medicines, even if they are not being given for pain, since we know that these medications will counteract and interact with each other. Let's have the next slide, Alan, which I have found very helpful, where we have given the diagram, which makes it very simple. As I say, a picture is worth 1,000 words. If we go at the top, pain assessment, does the person have pain, yes or no? Location, you're too busy, just circle the area where they're having the pain. It also makes you a good physician, because you're asking the patient about any area of pain, which really is part of a good assessment. It's also part of a good follow-up if you've treated somebody for pain. And again, your comments, your treatment plan. And then at the bottom, which is the diagram, mark the level of pain, which is something that's even used in all the hospitals now. More and more, every hospital, they have it right on the wall in front of the patient as a chart. And if somebody is willing, they can even expand it and put it in a chart form in every room, so that the patient can just point out and say, this is how I'm feeling. But pain assessment is as important as, say, urine incontinence or fall prevention, and these are going to become more and more critical in physician payment and physician evaluation, with star ratings, with medical home assessments and evaluations. Another word that I just wanted to make sure that everybody understands, this is an onerous requirement. It is painful to go through, but once one has gone through this and created a culture throughout the organization, and once one has created these forms, then one can audit oneself. And I recommend strongly that you have, even if it's a single physician practice or a multi-specialty practice, you have someone who will audit your charts, make sure that these things are checked correctly and followed up correctly, and then give you a score of how you are. And if it's done every 3 months, every 6 months, then it will help improve your record keeping, your compliance, and it will show if ever there's an outside agency looking in, this will be your firewall to show that you have made a good faith effort to keep your records clean and take good care of your patients. I think I'm done, Alan. I'll pass the baton to you. I think I did it right on time.
Yeah, you were great, with a minute to spare. Okay, I just want to mention there's a great article here beginning on page 39 by Dr. Singh, which is very good, and then a compliance checklist beginning at page 42 by Dr. Singh. Lester and Dr. Singh and I have also published a book. We're going to be revising the book. The revised edition is going to be out in a few days, and it's the Florida Physician's Guide to Prescription Controlled Substance and Pain Medicine Laws. You can buy it on Amazon or for your Kindle or your iPad or whatever you have. All right, Lester, any final words? No final words from Lester. Dr. Singh, thanks very much. Lester, thanks very much. We appreciate all the attendees, everyone who signed on, stayed on. If you have any questions whatsoever, please send us an email. We'll be glad to answer them. And thanks very much. Have a great day.
Thank you all.